Morning, everyone. My name is Matthew Horn, and this is the 6th Annual Illinois Construction Industry Legal Power Seminar put on by SmithAmundsen. Thank you for joining us. Like so many other programs, we're doing this virtually. We've tried to do it a little bit different, and instead of all of us just sitting at home on our computers via Zoom, we are actually in the office videotaping this live for you. First time I've been in the office in months, so it feels like I'm on vacation. So if you see me smirking or smiling, that's the reason. We've got a lot to talk about today, right? So 2021, we've had some big things happen in 2020. We've got bigger things happening in 2021. And the reality is this year is going to be basically a year of change, especially for employers. The Biden administration came in yesterday, and they wasted no time executing executive orders, and they have indicated that they are going to waste no time changing rules and regulations, adding rules and regulations, and doing all of those other things. So this will focus very largely on what we anticipate for 2021. Our program today is broken into 3 segments. So the first segment is on CDC updates, OSHA, COVID, and then with a brief discussion of construction contracts at the end. The second part, put on by my partner, Dennis Cont'd, concerns legal developments in litigation for 2021. And then the third one brings Jeff Risch, Bev Alfon, and Mike Hughes from our Labor and Employment Group. And they're going to have a panel discussion about all of the new things that you're going to have to be dealing with in very short order here. If at any point you have questions, we are taking questions, just type them in. I have a little screen right here where those questions will show up. If I can answer them, if we can answer them while we're talking, we'll do that. If not, we'll wait until the end of each individual segment. We have a short break in the middle. And so with that said, let's get started. All right, so the first presentation. Again, my name is Matthew Horn. I'm the chair of SmithAmundsen's OSHA Practices Group, which is a national practice group, and I am the co-chair of our construction group along with Dennis Cont'd. So COVID-19, right? We are just constantly bombarded with COVID-19 news from the state, from the CDC, from OSHA, and it's just going to keep coming until probably the later part of 2021, looking into fall and even winter of 2021. And it's probably going to be here to stay for a couple of years after that. So the 3 absolutes. I'm an employer. What do I need to know with regard to COVID? What do I need to do, right? Comply with all local, state, and federal orders. Read the fine print, right? So Illinois, when they rolled out their emergency order, you know, it said one thing, and then they changed it, and they amended it, and it said something else. So the unfortunate reality with COVID guidance is it's updating basically daily, and it's coming from multiple sources, and you need to stay on top of all of it. Identify and implement the applicable CDC and OSHA guidelines and standards. Again, you know, we've got a new director of CDC. We've got a new director of OSHA. Everyone's going to come in and they're going to make changes. And even when it's the same people there, the changes have been continuous. So, you know, you got to follow up and you got to stay abreast of what's happening. Now, what should you really be doing as an employer? You should be doing all of those things, following all of the rules. And most importantly, you should be preparing and implementing a COVID plan. And the COVID plan takes all of that information, it takes all of those updates and all of those standards, and it puts it in one place for you to rely on and you to share with your employees as to what your plans are to protect them from COVID and what you're going to do to make that happen. All right, what if I don't, right? And we've seen employers that are just saying, nah, you know, COVID-19, it's out there, I understand it, but, you know, we're not really going to do any of this, or we're going to try our best. Or you've also got people saying COVID-19 really isn't a threat. COVID-19 isn't real, so we're not going to do anything about it. What happens if you don't adhere to the guidance? Your employees get sick, right? People are getting sick either way, so your employees are going to get COVID. Claims by employees, right? We're talking about work comp claims, and we're seeing a ton of work comp claims. Beyond work comp claims, we're also talking about civil claims. we're talking about third-party claims. So, the exposure is beyond just work comp claims. We're talking about civil suits and things like that. Then claims by anyone who contracts COVID-19 from your employees, right? So your employee gets COVID, brings it home, gives it to his wife. His wife gets sick, his wife dies. We're seeing lawsuits filed like that too, and there will be more on this from my partner, Dennis. OSHA inspections and citations. Since March, the OSHA practice has been booming, right? I have dealt with 50 plus COVID-related OSHA inspections since March. I have dealt with 10 plus COVID OSHA-related fatalities since March. So, OSHA is working on COVID diligently, and in 2021, it's gonna explode exponentially with the new administration. Then negative publicity, right? So there's a lot of news stories out there. I've had a lot of my clients where, they have a COVID outbreak or they have a COVID fatality, and it makes its way into the news and it starts spreading on social media. So the Illinois order currently in place, restoring Illinois. What does the guidance require? It requires you to allow employees to work from home when possible, to ensure employees are adhering to distancing and when not possible, providing them and requiring them to wear masks, and ensuring visitors practice distancing and when not possible, encourage them to wear masks. Also posting all IDPH guidance regarding worker safety, right? So that's generally what the Illinois order provides. Now, CDC and OSHA guidance. What's interesting is the CDC has really been the one implementing the rules relating to COVID, and then OSHA is the one enforcing them. OSHA hasn't enacted its own COVID rules and regulations yet, though we think that's going to happen. So the CDC is putting out the guidance and the rules, and then OSHA is enforcing it. A lot of times OSHA has been issuing guidance that mirrors the CDC guidance, so you'll see that. But what are they essentially requiring? I've broken this down into two things: human resources and operations. So with regard to human resources, you need to implement flexible sick leave and supportive policies. You need to protect employees at higher risk, 65 or older, immunocompromised, employees with heart problems, diabetes, asthma, HIV, liver disease, kidney problems, and obesity, right? Again, I have been dealing with COVID-related fatalities in the OSHA context since March, and I can tell you that every one of those cases fell into this category of people: 65 and older, immunocompromised, and had serious health conditions. And if you have those employees working for you, you really need to look at what they're doing for you, whether they can do it outside of the office, and if they can't, really protecting them, because those are the people that are dying of COVID. You need to communicate those work policies, right? It's not just enough to have the policies. You need to tell people about them. Limit the travel for work, and also limit meetings. Now, with regard to operations, conduct a COVID-19 risk assessment and implement the necessary engineering and administrative controls. This is a construction seminar, so many of you are familiar with a job hazard analysis, right? Job hazard analysis goes through each type of job that you have at your company and identifies their risks. The suggestion is do that for COVID, right? Your people in the office have a different risk assessment and different risk exposure than the people outside of the office. The people that can work from home have a different risk assessment, different exposure. So for each type of job within your company, you should be doing an individual risk assessment. The other thing is, if OSHA ever comes knocking, if a plaintiff's attorney, a personal injury attorney ever comes knocking, if you have these things, it's really, really good for you, right? So beyond the protecting your employees, there's also the element of documenting the fact that you're doing these things. Educate your employees on how to protect themselves, right? Again, it's not just enough to have the information sitting on a bookshelf. You need to educate your employees. Again, with regard to the COVID fatalities I've dealt with, the crazy thing is half of those people have died at home. They have symptoms and they just think they're gonna ride it out at home. They can't breathe and they stay home. I mean, I had one case where the employee, it was a weekend, he collapsed, and then he went into his bedroom and laid down and took a nap, and he never woke up. So you need to tell them and you need to educate them and train them on what you're doing for them and what they should be doing if symptoms are onset. Conduct daily health checks, right? Screening questions, temperature checks. This one is really important. So, if you can take employees' temperature every day, great, right? You can have them use the handheld when they come in the office. I have clients that have had thermal cameras installed, especially in general industry. Have them go through the screening questions, and then to the extent you can, document all of this, right? Have everyone fill out a form for each day. I know it creates a lot of paper, but if anything ever goes sideways, it will be to your benefit. Require sick employees to stay home. This is especially difficult in the construction industry, right? It used to be a badge of courage to come into work when you didn't feel good, when you were sick, right? Those were the employees that we wanted. Things have changed, right? If employees are sick, if they have a cold, if they have symptoms, they have to stay home, right? There is no more honor in coming into work when you're sick. Not right now. Make employees that get sick at work leave, right? If you see someone going in and they're getting Advil, or they need to rest, or they're laying down, or they're burning up, send them home. Policies for distancing, right? Stagger shifts, reduce capacity. In the construction context, don't allow more than one employee to ride in a truck. I know that people don't want to take their personal vehicles out to the job, but you don't want 3 or 4 people in a truck together. Implement engineering controls. This is big in the office context and in the manufacturing context. Physical barriers, plexiglass, right? Our law firm, there's plexiglass everywhere. You go to a restaurant, plexiglass. Banks, plexiglass. So same thing within your office, same thing within your operations where people are within close proximity of one another or interacting with others. To the extent you can, install plexiglass. Proper ventilation and ventilation systems. This is a big one. Leaving a window open can help. I mean, it really does help. There's a Wall Street Journal article out there about the benefits of leaving windows open in offices to avoid COVID. At your construction company, in your shop, leave the doors open, right? Yes, it gets cold, but it helps stop the spread of COVID. My kids are in school. They leave the windows open. My kids wear jackets in class, and that's fine with me as long as they're out of the house, right? If they're a little bit cold, that's fine. Personal protective equipment, right? So, anything that people need in terms of personal protective equipment, face masks, face shields, respirators, have those things. Implement administrative controls, and this is the face mask and the other things. And then routine cleaning and sanitizing, right? So this is another big one. This is one that OSHA has been digging into on a lot of my COVID cases. Is their question is, all right, after this person got COVID, after these employees got COVID, what did you do to sanitize? What did you do to clean? So, especially in the office context, you should be having your office cleaned and sanitized routinely. If somebody gets a case of COVID, their workstation should be cleaned and sanitized immediately. So the CDC latest guidance, right? We kind of talked about it. If employees become sick during the day, send them home and sanitize their station. Compile information on the people who had contact with the employee during the time that the employee had symptoms in 2 days prior, and then notify them and quarantine them, right? So again, an employee comes into your office, an employee calls you, they say, I got COVID, right? Think about who have they come in contact with? Who have they been dealing with for the last couple days? And then tell those people to quarantine, right? So you need to do an investigation when it comes to each case. County health departments are helping people track and test. I know Cook County hasn't been great about that, but outside of Cook County, the county department will help you do that. And then others at the facility with close contact within 6 feet of the employee during this time would be considered exposed, right? So if an employee has close contact with this employee that just told you they have COVID, they got to quarantine. Now, this is something that's been changing since March, right? And it changes, every couple of weeks at this point. So when can I return to work after having COVID-19? When can my employees come back? So if they have COVID-19 symptoms and they have COVID, they can come back 10 days since the symptoms first appeared, 24 hours with no fever and medication, and other symptoms are improving, right? So for mild cases, 10 days after symptoms first appeared, they can come back, right? For not mild cases, let's say they're having symptoms, you basically need to wait until the symptoms are resolved. If I have no symptoms and a positive test only, you need to wait 10 days since the date of the positive test and still have no symptoms, right? So again, the easiest rule just to remember is 10 days since symptoms first appeared, assuming they don't have a serious case. Now, if an employee has been exposed to someone with COVID-19, then they have to quarantine for 14 days, right? And this kind of doesn't make sense mentally when you think about it. People are like, all right, if I have COVID, I can come back after 10, but if I don't and I'm exposed, I have to wait 14. And that's just because that's the period of time that it takes for COVID to rear its head. I have had COVID. My entire family has had COVID. We got it all at the same time, but we started showing symptoms at different times. I took longer than my wife and my kids. So, that's the justification for the 14 days, is if you get it, the symptoms will appear within 14 days. Okay, what constitutes exposed for purposes of quarantining, right? And this is where, people really need to be aware of the rule, because the rule really isn't as debilitating as people think, because close contact is defined as 6 feet for 15 minutes or more, or had physical contact with that person, right? 6 feet, within 6 feet for 15 minutes or more. 15 minutes is a long time, right? How many people are within 6 feet of somebody else for 15 minutes or more at work? Unless their workstations are right next to each other, or unless they're in a truck together, usually it's not that many people. We have seen that the CDC is permitting a 10-day quarantine in certain cases if you have a negative test and things like that, but be very careful with that. Frankly, I expect the new CDC to eliminate that. And but again, this is something that they're saying you can do, but they still really have the 14-day quarantine period. So if you really want to dig into that, you can, but be very careful. There is an exception for critical infrastructure workers, right? So the quarantine for exposed workers, there is an exception for critical infrastructure workers whose absence would shut down operations, right? So early on in Illinois, construction companies and everybody was identified as essential, and they were given guidance, basically, go ahead, unless you have COVID, then you got to go home. The CDC has tweaked this a little bit. So if you're a critical infrastructure company and you have employees who are exposed, they may be able to return to work while wearing face masks all of the time, but only if their absence would shut down your operation, right? So only rely on this exception if absolutely necessary. COVID plan, right? This is when my clients called me and they say, Matt, what should I be doing? This is what I tell them. You need to prepare a COVID plan, right? You need to draft a document, or you need to compile via alerts, guidance, emails, whatever, a COVID plan. Just like a safety plan, right? And you need to adopt it and you need to train on it. Now, what are the critical elements of a COVID plan? We've kind of talked about it. If COVID-19, don't work until 10 days after symptoms onset, right? Evaluate workers for COVID. If signs they must leave, take their temperature, ask questions, document and act on temperature and answers. If exposed to someone with COVID-19, then they need to quarantine. Elements of a plan continued. So outline what you're going to do, right? It doesn't need to be fancy. It doesn't need to be 50 pages. It can be 2 pages. It can be 4 pages. But identify what you're going to do. Distance and spread workers out. Stagger start times. Designate traffic on stairs, right? We saw this in a lot of grocery stores where they were saying you can only go up this aisle this way and you can only go that way down that aisle. Install plexiglass and barriers. Provide and require masks if not able to distance. Make soap, sanitizer, and wipes readily available. Have bathrooms routinely cleaned and sanitized. This includes porta potties, right? I've been involved with an outbreak that stemmed from porta potty usage. Do not meet in large groups. Eliminate communal water jugs, coffee stations, and break areas. The other one is a lot of transmission of COVID happens in the break room, happens in the lunchroom, right? They put the plexiglass barriers up on each cubicle. They make sure people are wearing masks. They're staggered. Then it's lunchtime. Everybody goes, sits at the table together, takes their mask off, starts talking and resting and eating, right? Again, I've seen a lot of outbreaks from the lunchroom. So, don't think about everything except the lunchroom. I would actually look probably at the lunchroom first. OSHA enforcement of COVID-19 protections, right? So where's OSHA at currently with regard to what they're doing with COVID? So OSHA is overwhelmed with calls and complaints regarding COVID. Everybody is calling OSHA, complaining about COVID. OSHA used to have, and I do work nationally with OSHA, and every office you would call, they had an assistant that would pick up and talk to you. Now when you call all of them, it's a pre-recorded statement, usually about COVID and what to do if you have a COVID complaint. So they're overwhelmed. OSHA offices, for the most part, are all closed, and OSHA employees are working from home, but they're slowly opening back up. For my clients in the South, the OSHA offices, some of them are open, but generally in the northern states, the OSHA offices are still closed and the inspectors are working remotely. If somebody calls to complain about COVID at your business, what typically happens? For the most part, OSHA is allowing employers to self-report. As long as there's no fatality, there's no outbreak, there's no serious hospitalization. If somebody just calls and says, my employer's not requiring masks or my employer's not requiring distances, and this is happening all over the country, right? OSHA will send you a letter and will allow you to self-report your findings. Now, the self-report, should it just say when you respond, no, we're doing this? No, you shouldn't. You should give them your COVID plan. You should outline the steps that you've implemented to protect your employees. You should identify the dates that you implemented those. You should provide photographs and emails and documents backing all of that up. That's how you get OSHA to close the file and walk away. As I indicated, there are a lot of COVID-19 fatality inspections happening from OSHA. This is really what OSHA is focusing their inspection and enforcement efforts on right now. And why? Why are there so many of these? Well, because employees passing away outside of work for the first time is now the employer's problem, right? So in all of my COVID-19 fatality inspections, none of the employees have died at work, right? They all die over the weekend, they die at home. And so for the first time ever, we have people dying of natural causes, and OSHA that's kind of falling into its jurisdiction, and now it's doing inspections concerning that. So then the reality is, from what I can tell, most people that are dying, whether they're dying of COVID or they just have COVID or they got over COVID, it's all attributed to COVID, right? So if you have an employee dying right now, there's a good chance that they have COVID or had COVID, and so they're going to earmark that on the autopsy report, and it's going to trigger an OSHA inspection. OSHA actions regarding COVID-19. So again, OSHA doesn't have its own standards right now relating to COVID. It's just enforcing the CDC guidance. So if OSHA conducts an inspection, even if it's a fatality inspection, and they determine that you're following the CDC guidance and you're doing the things you're supposed to be doing, then there's no citations, right? And for the most part, in all of my COVID cases, there have been no citations issued because the client is doing the right thing and they're able to document that, and we're able to explain that to OSHA. Now, if there's a OSHA inspection and they identify that you're not following the guidance, right? You're not requiring masks, you're not distancing, you're not quarantining, then they cite you, right? And, OSHA took a lot of heat from especially the Democratic side of Congress about not doing enough, not issuing their own standards. And so in response to that, what OSHA did is they started citing people. And when they cite people for COVID, they have been issuing press releases to try and demonstrate to everybody that these are the things that they're doing, right? Don't tell me I'm not doing anything. Don't tell me I'm not doing enough. Here's a press release talking about how I cited this employer, and here's another press release. We've seen a lot of this about meatpacking, right? Meatpacking, hospitals, nursing homes. OSHA is killing them with the press releases. Since OSHA currently has no COVID standards, they're usually citing employers under the general duty clause, right? And the general duty clause is a catch-all that says basically you have to provide a safe environment. Also, recording and reporting, failure to provide the appropriate PPE, failure to provide the appropriate respiratory protection. So, if OSHA thinks that you're not taking this seriously and you're not doing the right thing, they will cite you, and they will find citations to cite you under, standards to cite you under. OSHA recording, this is a big one. This is a big one with COVID. OSHA has indicated that it's requiring employers to record and report employee COVID cases in certain circumstances, right? So just like somebody trips and falls at work and gets injured and they have to go to the hospital, that goes on your 300 log. Somebody gets really hurt at work, you have to report it to OSHA. OSHA's saying you have to do all of those things when an employee gets COVID, right? Now when do I need to do that? An employee has a confirmed case of COVID, all right? So they have a positive test. The case is work-related, and this is the one that we really need to talk about. And the case involves one or more of the general recording or reporting criteria, right? So for recording, they've had medical treatment beyond first aid, days away from work. For reporting, hospitalization, death, etc. Now, what constitutes a work-related case of COVID? So in order for a case to be work-related, the employee has to be infected at work. It's not enough that he or she contracts the disease outside of work and displays symptoms at work. It's not enough that they call you and say, I got a positive COVID test. So OSHA has issued guidance on this as to what you need to do to make a determination as to work-relatedness. So the guidance says it's recordable if the employer makes a reasonable determination that the case is work-related. How does an employer make a reasonable determination as to whether the case is work-related or not? They basically have to do an investigation. So you basically have, for every COVID case, you have to do an investigation. You have to ask the employee about their exposure to COVID. You have to look at the objective evidence available within your company. So do you have an outbreak? Does this employee's co-employee who works next to him have COVID 10 days before? So you need to look at all of the evidence. You need to talk with the employee. You can look at social media. You can look at emails. And you, if you really want to do it right, you can ask the employee that gets COVID to fill out a questionnaire. And we have a questionnaire that we've drafted that you can provide to your employees to fill out. But again, you need to be able to make a determination. Now, if this is the only employee at your company that has COVID, right, there's a reasonable determination that they didn't get it from anyone at work because nobody else has COVID, right? Whereas, let's say 10 people working within 20 square feet of each other with cubicles next to each other all get it and all have an outbreak. If you can identify the first person that brought that in, great, not work-related, but the rest of them probably work-related. So you need to do an investigation on a case-by-case basis. COVID-19 and OSHA retaliation claims. So this is going to be a big one. This is already happening, and I think it's only going to get bigger. So for a retaliation claim under OSHA, the employee must show that he or she engaged in a protected activity, such as raising a safety concern or refusing to perform a job function for fear of safety, suffered employment termination, and there's a causal link between the two established, right? Protected activities include calling OSHA, refusing to work due to safety or COVID concerns, reporting an alleged unsafe work environment, complaining about work-related injury or illnesses, or testifying in an internal or OSHA investigation, right? So if you have an employee that's constantly complaining about your COVID protections, that's calling OSHA, telling OSHA that you're not doing enough, be very careful if there's going to be any sort of employment-related action taken against them, right? Do not terminate due to raising COVID concerns, issues. Rather, focus on the employee's behavior and conduct, right? A refusal to work solely due to fear, particularly unsubstantiated fear, that is not rooted in any specific or real safety hazard, may be considered job abandonment, right? The labor and employment, we'll talk more on this later. But if you have an employee that needs to be at work to do their job and says, I'm not coming in because I'm afraid of COVID, I understand you're doing everything right, but I'm still not coming in, that could be considered job abandonment. All right, OSHA in 2021 and beyond. All right, so we got a new president yesterday. He's going to drastically change the course of many things, including the Department of Labor and including OSHA. Boston Mayor and former union leader Marty Walsh was tapped to lead the Department of Labor, putting him in charge of OSHA. I just saw yesterday that either Mr. Walsh or the Biden administration has selected a safety manager with I believe it's the steel union, to serve basically as the head of OSHA. So, the new administration's OSHA leadership is backed by major unions across the country, right? They're going to pursue a pro-union agenda, implementing rules, making it easier for employees to unionize. What else are they going to do, right? They're going to adopt more regulations. They're going to do more inspections. They're going to issue more citations. The fines for the citations are going to be increased. The classifications are going to be increased, right? So the truth is, we didn't even have an OSHA group until Obama took office, right? Because under the Bush administration, OSHA, there really wasn't that much bite. They would issue a citation or two, maybe $1,000 or so, but we didn't really see OSHA getting aggressive until the Obama administration. The Trump administration softened that a little bit. They didn't roll it back too much, but I think where OSHA was going under Obama is just going to increase exponentially under the Biden administration. So I think you're going to be dealing, if you haven't dealt with OSHA, you're going to be dealing with them. And if you have been dealing with them, you're going to be dealing with them a lot more. So I expect rules enacted by Obama but rescinded by Trump to resurface again. The one that quickly comes to mind was the rule requiring employers with more than 250 employees to electronically submit their 300 logs as well as their 301s. So Obama rolled out this rule. Trump stopped it, and I expect Biden to adopt it again. So expect OSHA to issue COVID-19 standards, right? So they haven't done that. They haven't adopted any more standards in response to COVID, but the Biden administration has made it clear that they're going to do that. So they're going to be issued. We expect them to be issued probably within the next few weeks. We think it's going to be a priority for them. There's some talk that the OSHA standards will just mirror the CDC requirements, right? So it'll just give OSHA a little more teeth if you're violating the CDC guidance to cite you, right? It'll just make it easier. Which if they did that, it probably wouldn't be a huge deal. Yes, you're going to have more standards. Yes, it's going to be easier for OSHA to cite you, but they're basically going to be citing you for the things they would be citing you for now. What's of greater concern? Of greater concern is that they adopt something similar to what OSHA, so California OSHA, has rolled out. And Marty Walsh was tapped to lead the Department of Labor, but the other person who was considered was the head of California OSHA, right? So she was in the running. She wasn't selected, but, we see the administration trending towards the California OSHA type mentality, right? What do the Cal OSHA standards provide? And if you're in California, I'm sorry that you have to deal with these. If you're not in California, I'm happy to tell you that you don't have to deal with these just yet. But the standards adopted by Cal OSHA are employer crushing. What do they basically require? You need to provide employees with no-cost testing during work hours, right? So if there's a COVID case, if there are people exposed, you need to provide the employees with testing for COVID at no cost during work hours. So you can tell them they can go get tested off-site, but you have to pay them for that. The other option is to have them tested on-site, in which case you need to bring in a service provider. Now, if there is an outbreak, right? What constitutes an outbreak? 3 or more cases in a 14-day period, right? That's probably most employers across the country at this point have dealt with an outbreak as it's defined here. So if there's an outbreak, you need to provide all employees with weekly no-cost testing during work hours, right? And so this is the one where my California clients have called me and just said, Matt, this is just not feasible. The service providers out here providing on-site COVID testing want 6 figures to come and embed themselves in the operation and do the testing. We can't afford to send the employees off-site during work hours. They won't come back. So this has been a major headache. And if federal OSHA adopts this, it's going to be everybody's headache, right? 20 or more cases in a 30-day period constitutes a major outbreak, and it triggers additional requirements, including upgrading your ventilation systems. So hopefully that doesn't happen. Hopefully federal OSHA will just adopt the CDC guidance as the standards, but we could see them adopt the Cal OSHA standards just as easily, or maybe a softer version of that. But be aware that that's what's happening. All right. So COVID-19 and construction contracts. I know that, and I looked at the list, and some of you are not construction companies, but many of you are. So this will probably apply to you, even if you're not in the construction industry, to the extent that you have contracts with vendors and others. So what are the contract provisions implicated by COVID-19? So we've got the applicable law section. And I've tried to include this in the order that they typically appear within a contract. So applicable laws, right? The laws governing that contract have been impacted by COVID-19. The delay provisions, the force majeure provisions have been impacted. The suspension provisions, right? We saw a lot of construction projects suspended. We saw financing pulled. And then claims for additional time and compensation, right? So we saw a ton of activity with regard to delays and claims for additional compensation and suspension from March to probably June or July. And then it slowed down a little bit. But now we start hearing about there's another COVID variant, right? It's more aggressive. It's coming from the UK. It's coming from China. So who knows? They say right now that the vaccine covers that, but the reality is, even if we get through this current situation with COVID, I think it's very likely we're going to be dealing with another situation in a fairly short time period here. I hope I'm wrong, but we need to be prepared if it does. So contractors generally want additional time and compensation for delays or changes in work regarding COVID-19, right? But those typically aren't allowed, or if they're not allowed by the owner, they need to negotiate them downstream accordingly, right? So on the construction project context, let's say that the owner says there's no damage for delay. And then I'm delayed 4 months because of COVID, or I'm delayed 8 months because of COVID. That's something that you need to deal with, right? And so in your contracts, look at what's happening with your contract upstream relating to COVID and make sure that you pass it downstream. These are some of the examples that I have dealt with since COVID, and I think that these are going to continue to rear their head. So the workforce depleted, right? Right after COVID hit, I had a lot of clients who were saying that their workforce was either sick or they were refusing to come into work, right? That delayed the client's work. Material delayed. So in all my construction projects where they were getting material from overseas, Europe, wherever, tile, cabinets, flooring, all of that was delayed by COVID. Owner stoppages, so financing was pulled. Owner stopped the project. Owner was concerned about the spread of COVID. All of those things caused issues. Refusal to work by subs. Again, we had people saying, I'm not coming to work. No inspections. So, and I know on the North Shore in the Chicagoland area, there were a number of municipalities that said, we're not going to be doing inspections. We're not going to be going on site. We're not going to risk our inspectors. Slowed down the project, delayed the project, suspended the project. PPE and COVID protection costs. I have a COVID claim right now for a client that's multi-millions of dollars, right? Why? They had to get a tent. They had to get trailers. They had to do all of these things. There were production losses, right? Instead of their employees being able to go into the work trailer and take lunch, they had to walk to their cars. It cost them 15, 30 minutes. But these things start to add up. staggering work shifts, right? Extra supervisory costs, increased general conditions. I mean, all of these things, I've seen all of these things happen in regard to COVID. So, when you're looking at your contracts moving forward, account for these possibilities, right? I remember after September 11th, right? Everyone started looking at the terrorism provisions in their contracts and the terrorism provisions in their insurance contracts. And these are things that people had never really looked at before, right? And so, the same thing's happening with COVID is a lot of these provisions, I even as an attorney glossed over until I realized that this was a reality. So you need to account for the new reality when you're reviewing your contracts, when you're negotiating your contracts, and all of those things. So, negotiate based on your past experience. What happened to you as a result of this pandemic, right? Again, hopefully it's not an issue in the future, but I think it's probably going to be, right? AIA and other forms may reference a pandemic, government orders, a change in law, etc. Those are the key words that you want to be looking for, right? If you get a contract from the owner and it says no extra time, no extra compensation for delays caused by pandemic, you need to deal with that. You need to look at, okay, what happened to me with COVID in 2020? Was I delayed? Was I suspended? Did my sub stop working? Was I unable to get material? And you need to account for that, right? The one thing that I'm encouraging is I'm saying, if you want to really get into it, if you were really impacted by COVID, go beyond the generic terms and get into the specifics, right? Included here is a provision that I worked with an attorney for the owner in drafting as to what happens in this project that's probably not going to start till the middle of 2021. It's probably going to go through 2022. What happens if we have another COVID-19 outbreak, right? And we negotiated this for a while. There was back and forth, right? And we finally found a compromise. And that's what you need to do. So, COVID-19 delay claims, right? Let's say you're dealing with a delay claim stemming from COVID-19. You need to review your contracts for the deadlines, the notice required, and whether you're entitled to an extension of time or additional compensation, right? I represent general contractors and owners, and I was dealing with, on behalf of them, claims from subcontractors and claims from contractors saying, in light of COVID, we're going to be delayed for 3 months. And we want to get paid, we want an extension of time, and we want to be paid general conditions for those 3 months. But in the contract, there was nothing about that, right? There was a section that provided if your work is stopped, you're entitled to additional time and additional compensation. But as everyone in the Chicagoland area knows, construction work wasn't stopped, right? So these contractors were submitting these claims basically just saying, we think we're going to be delayed. Some of our employees aren't coming into work, and so here's our delay claim. And, we dug through the contract, and they weren't entitled to assert a delay claim. So, just know that, before you assert a claim or when you're evaluating a claim, look at the contract provisions and see what they say. Timely assert claims. So most contracts, including the AIAs, provide that you have to assert a claim within 7 days or 10 days or 14 days, right? And so in this context with COVID, COVID really hit in March. And so my clients that had those provisions, I was saying, submit the notice, right? We don't need to know what the full impact is, but you need to at least comply with the notice requirement and tell them, we expect there's going to be this delay that falls under this provision of the contract. Here's what we expect the delay to be. Support your claim with proof, right? So once it's all said and done, so you've submitted your first notice of claim, once you finally get through that delay, submit a supplemental claim and support it with critical path, invoices, emails, photographs, everything that you need to support your claim. And then you need to be prepared to negotiate, right? Because even when my clients who have valid claims are submitting them, the owners, the general contractors are saying, come on, we didn't expect this, you got to work with us, right? So, everyone wants to rely on the contract until it's not good for them. So we need to be prepared to negotiate. All right. That is it for my segment. I am trying to pull up the questions to see if there are any questions on this tablet in front of me. And, oh, I got it, Emily. Thank you. All right. All right, I'm going to start at the first one. Okay, the first question was, how broadly is the critical infrastructure designation being interpreted? Is it all construction? So you're dealing with two separate things, right? In Illinois, the order has said that construction workers are essential employees, right? And then in the CDC context is how when they talk about critical infrastructure. So know that there are two separate competing kind of definitions there. If you look at the critical infrastructure definition provided by the CDC, no, it is not all construction, right? It is basically infrastructure. So, you know, you're talking about communications, you're talking about, you know, critical services, sewer and water. I mean, really infrastructure is covered by the critical infrastructure. The Illinois order is different. It says that basically all construction is considered essential. So, you know, how do you kind of reconcile those two? I think you need to be careful, right? So if you fall within the critical, if you're a construction company and you perform critical infrastructure activities, obviously you fall within the critical infrastructure exception. If you are a construction company that falls outside of the critical infrastructure designation and activities, you know, then I would be careful. And I would, you know, in these cases, the best thing to do is to read all of the guidance as narrowly as possible. So if you're a construction company and you're an essential worker, but you're not critical infrastructure, I would caution against relying on the critical infrastructure exception. Okay. Is it okay to require employees to take their own temperatures? Absolutely. Yes. 100% you should be doing that. Are numbers for an outbreak at the whole company or per work location? So based on the Cal OSHA standards, it's basically work location. And they have said, you know, if you have multiple buildings within your operation, it can be confined to just one building. So the good thing, again, is that we're not dealing with that with federal OSHA yet. That's just Cal OSHA. And Cal OSHA does define that basically as a work location or a work area within a work location if the work location is expansive. Have I seen citations issued for employers for failing to submit 300A data as required by 1904.41? Yes, I have. And more importantly, what OSHA has started doing, and it was derailed a little bit by COVID-19, is OSHA is identifying employers who are not submitting their 300A data, who should be, and then they're conducting inspections of those people, saying, you didn't comply with this requirement. We're now entitled to come in and conduct an inspection, essentially of your entire facility. And I've had that happen in a number of cases. So, you know, beyond just being cited for failing to provide that data, they're using the failure to provide that data as a reason to come in and do an inspection, right? So they do an inspection, they cite you for failing to provide the data, and then they cite you for 10 more things that they found during their inspection because you failed to provide the data. All right. My little tablet seems to have shut down on me again. I think that was the last, oh, here, I got it up again. That's it. That was the last question. So, thank you very much for your time. Next up, we have Dennis Cotter on legal developments and litigation for 2021, and that will be starting shortly. Thank you.